Okay, let's dive right in. Welcome to this explainer on third-party harm claims. We've designed this specifically to be your definitive study guide for that upcoming Module 9 essay. Now look, if you've been drowning in case law, statutory codes, and, those incredibly complex legal doctrines, just take a breath. We're going to distill all these updated sources down to their core mechanics. That way, you can walk into your exam feeling absolutely 100% prepared.
Here's our roadmap for this review session. We'll start with 1. Third-party harm fundamentals. Then 2. Wrongful death versus survival. 3. The prenatal torts divide. 4. Loss of consortium. And finally, 5. Essay prep and a quick Socratic Q&A. We're moving chronologically from the basics, through those heavy-hitting landmark cases, and finishing strong to really lock in your active recall.
Section 1. Third-party harm fundamentals. Right, so we have to start with the baseline premise here.
Third-party harm claims ask a super fascinating legal question. What actually happens when a negligent act ripples way beyond the immediate victim? Historically, traditional common law created this completely perverse financial incentive. Think about it. If a defendant's negligence severely injured someone, they could be sued for millions. But if their negligence instantly killed the victim, well, all civil liability practically vanished. Literally, the claim just died with the person. Thankfully, modern statutes stepped in to fix this incredibly harsh rule.
That brings us to Section 2, Wrongful Death versus Survival, featuring the Quiroz v. 7th Avenue case. This is our first major procedural trap, and one you absolutely need to nail for your essay.
You really have to understand how modern statutes split fatal negligence into two completely separate claims. Notice the strict boundary line here. A wrongful death claim belongs strictly to the heirs. It's for their personal grief, the financial support they lost going forward, and funeral costs. On the flip side, a survival action belongs to the estate. It preserves what the deceased person lost out on between the moment of the negligence and the actual moment of their death.
The Quiroz court lays it out perfectly. They state that a cause of action for wrongful death does not affect a survival of the decedent's cause of action. It gives to the representative a totally new right of action. Basically, they're saying these are not overlapping concepts. They are entirely distinct legal capacities addressing completely different injuries. In Quiroz, a mother sued a nursing facility after her dependent adult son died, but her legal team totally failed to recognize the difference between these two statutory vehicles until it was way too late.
The black-letter law takeaway from Quiroz is that you simply cannot conflate the two. So the absolutely crucial point for your essay is the relation-back doctrine. In Quiroz, the plaintiff filed a timely wrongful death claim but totally missed the deadline for their survival action. When she tried to amend the complaint later, the court said absolutely not, because they enforce entirely different injuries. Mixing these two up leads to a procedural train wreck where a late amendment is completely time-barred. Seriously, do not make that mistake on your exam.
All right, Section 3, the prenatal torts divide, anchored by Smith v. Cote. Let's move into a highly nuanced area where bioethics, medical malpractice, and the limits of tort law all crash into each other.
When you're outlining your legal analysis, you have to untangle these complex concepts to know exactly who is suing and what they can recover. Notice the massive difference in outcomes depending on whether the parents bring the suit versus the impaired child. Let's look at the black-letter law from Smith v. Cote. Here, the physician negligently failed to inform the mother of her exposure to rubella, depriving her of an informed reproductive choice. The real significance of Smith is that it officially recognizes wrongful birth. It allows parents to recover the real, staggering financial burdens of treating a congenital illness. But, and this is a massive but, it firmly blocks wrongful life claims. Courts simply refuse to allow a child to claim their very existence is a legal injury.
And here's something you really need to keep in mind. As Professor Burke neutrally pointed out in his seminar, you've got to be aware of how shifting constitutional frameworks impact tort law. Because the Dobbs decision returned abortion regulation to the states, proving the causation element for wrongful birth, that but for the doctor's failure to warn, the parents would have legally terminated the pregnancy, has become a severe legal quagmire in certain jurisdictions. It's a hugely important complication to be aware of.
Moving right along to Section 4, Loss of Consortium, looking at Spangler v. Walmart. Shifting gears from fatal and prenatal claims, let's examine non-fatal relational harm.
This asks what happens when a spouse is severely injured and the marriage itself suffers the blow. Think of loss of consortium as the law officially and empathetically recognizing that a severe physical injury to one spouse structurally devastates the marital society of both. It's a heavy, deeply personal burden for families. Keep in mind it is a derivative claim.
That means it relies entirely on the underlying negligence against the physically injured spouse. In this case, Mrs. Spangler slipping and falling in a commercial restroom, which sadly led to multiple severe back and neck surgeries.
20 grand. That is the amount the appellate court awarded Mr. Spangler for his loss of consortium. Now, Walmart tried to argue that Mrs. Spangler had a complex history of prior medical issues, implying the marriage was already strained anyway. But remember the eggshell plaintiff rule. A defendant takes their victim as they find them. Pre-existing medical conditions do not magically erase a tortfeasor's liability for inflicting new disruptions on a marital dynamic.
Okay, Section 5, Essay Prep and Socratic Q&A. Let's put this whole shebang together. It is time to prepare you to execute a high-scoring Module 9 essay.
We're going to review some insider advice straight from your professor, and then jump into some active recall to make sure these concepts are locked in. You can absolutely crush this exam if you keep these tips top of mind. First, ditch the rigid formatting. Let your legal analysis flow naturally without explicitly typing out issue or rule as headers. Second, focus your energy on the heavy-hitting mechanics of death and survival. Because prenatal harm laws lack a national majority consensus, they just aren't quite as testable for deep regional nuances. So stick to the basic frameworks we just covered. You've got this.
All right, let's test that active recall with our first Socratic question. Think back to the prenatal torts divide and the Smith v. Cote decision. Can a child successfully sue for wrongful life in a majority of jurisdictions? What's the black-letter law here? Take a quick second.
Did you get it right? The answer is a definitive no. Remember the core holding? Courts simply refused to declare that it would have been better for the plaintiff to have never been born. It's a calculation that the legal system asserts is structurally impossible to make. Let's keep the momentum going, moving to statutory mechanics. Under California Civil Procedure Section 377.34, what specific damages are entirely barred in a standard survival action? Think about those strict boundary lines between the heirs and the estate.
The answer? The estate can only recover measurable financial out-of-pocket losses incurred before death, like medical bills or lost wages. Damages for pain, suffering, or disfigurement are strictly excluded. The one rare exception is if a heightened statutory threshold is met, like proving reckless neglect under the Elder Abuse Act, which unfortunately the plaintiff in the Quiros case realized way too late.
Okay, final question. Let's test that massive procedural trap we discussed earlier. Does an untimely survival action automatically relate back to a timely filed wrongful death complaint?
The answer is no, absolutely not. This is the ultimate trap for the unwary litigator. If you miss the specific statute of limitations for the survival claim, it is permanently barred, regardless of how quickly you filed the wrongful death action. They are distinct vehicles driving on completely different legal tracks.
As you head into your exam prep and start writing your Module 9 essay, I want to leave you pondering this final provocative thought. We talk endlessly about tort law making people whole, right? Yet, when it comes to the ultimate loss, the law often coldly calculates financial support while actively ignoring pure emotional grief. It really highlights the profound boundaries of legal liability. Best of luck on your essay, and thank you so much for joining this explainer session.